Robert Roberson spent 2 hours trying to revive his dying daughter, and for that, the state of Texas sentenced him to death. And then 19 months ago, a Texas court freed a man convicted by the same doctor on the same science, in a case that mirrors this one point for point. 1 week later, the state of Texas set a date to kill Robert Roberson. Same theory, same expert, same statute, but opposite outcomes. This is not a story about a diagnosis. It's about a system staying consistent rather than admitting it was wrong. The case against Robert Roberson rested on shaking baby syndrome, and for many experts, that diagnosis is now discredited. And yet, more than 2 decades later, Roberson is still on death row. Not because the science held, it clearly hasn't, but because no one in the judiciary applied the very law lawmakers wrote to free him. The lead detective who put him there in the first place has since changed his mind. And there's a line in the autopsy report that the state still leans on right now to keep him there. We'll get to that shortly. Chapter 2, the case against Robert Roberson. The theory the prosecution put to the jury was blunt. Nikki Curtis died at her father's hands from abuse consistent with shaken impact syndrome. Full stop. They had the science. At the time, the Triad, subdural bleeding, brain swelling, retinal hemorrhages was treated as presumptive evidence, meaning that it strongly suggested shaking. There was one exception to that rule, a major traumatic event, such as a car accident. And here is where the record and the prosecution's story part ways. Nikki Curtis was not a healthy child who suddenly collapsed. She lived with a ledger of illnesses, chronic infections, a pattern of apnea episodes where she stopped breathing altogether. Now that word, apnea, was the word that the jury was never permitted to weigh in their deliberations. They were handed half the picture, because on January 28, a father and a grandmother carried her into the hospital after 5 days of vomiting, coughing, and diarrhea. The physician prescribed Phenergan, a heavy anti-nausea drug, and then sent her home to convalesce. By morning, the fever had climbed, and so Robertson took her back to the hospital. Her temperature had reached 104.5 degrees, and the doctor's response? Another prescription, only heavier this time, Phenergan with codeine, and the same instruction, go home and convalesce. The state story needed you to believe one thing, that this was a father who did nothing for his daughter. But the record shows something else entirely, a father who carried a 104.5 degree child into the same hospital twice and was sent home twice. And then years later, the FDA said Phenergan should not be used in paediatric patients less than 2 years of age because of the potential for fatal respiratory depression. And codeine carries another serious risk, including slowed or difficult breathing or even death. 2 warnings that did not exist on the morning the prescription was written. The next morning, Robertson wakes. Nikki is blue. Her breathing is faint, slipping away. He tries to revive her and then calls the emergency services. Doctors worked throughout the night and into the next day trying to keep Nikki alive. But they couldn't. Nikki passed away. The Triad. In 2002, the jury was asked to believe something very scientifically specific, that the Triad could mean only one thing, that no fall, no illness, no accident, no prescribed medicine could ever carve the pattern into a child's body. Dr. Janet Squires, a child abuse paediatrician, testified that Nikki's injuries could not be explained by a simple fall alone, only by shaking. The science, the jury was told, was settled. Doctors trusted it, prosecutors wielded it, and juries followed it. And here's the part the state never had to win, because the defence, Robert Roberson's advocate, conceded it. Robertson's own lawyer opened with the words, "Unfortunately, a shaken baby case." They didn't challenge the diagnosis. They accepted the triad as fact, argued only that he hadn't meant to kill her. And once you accept the story as shaking, the rest of the narrative writes itself. Chapter 3. The Defence. The state held fast to its version of events long after the science began to shift. It has never really let go of its theory of the case. The medical examiner who performed the autopsy, Dr. Jill Urban, pointed to bruising on Nikki's face and head. Evidence, she said, of impact and not just shaking. That's the line from the autopsy we mentioned before. It's also the line that the state's office reached for in 2024 when they released the report to the public and said it proved this case was never about shaken baby syndrome at all. 10 independent pathologists have since reviewed that same report and called it unreliable. Brian Wharton, the lead detective who built the case, has since said he was wrong about it. The man who put Robertson on death row now argues for his innocence, but the state still leans heavily on shaken baby syndrome. That's the fight that hasn't ended, not whether the shaking science holds, but whose account of a dead child's body gets to be the last word. And keep that in mind, because the rest of this section is about to take the state's foundation apart. The sick child argument. The science has a blind spot, and the jury never got the chance to see it. Pneumonia, sepsis, hypoxia, and metabolic disorders, each one capable of carving the same pattern the state called a fingerprint of violence. And in that era, the triad didn't open a debate, it shut the case. So somewhere in a hospital hallway, a father was told that his daughter's injuries proved abuse. Nobody told him that pneumonia could look the same on a scan. Nobody told the jury either that the new medical evidence says that Nikki's death may have had a far more ordinary cause, the kind that unfolds in a hospital bed, not in a courtroom. That isn't wishful thinking from hired experts. It's the very argument that has already stopped Robertson's execution twice, dead in its tracks. The fallen diagnosis. The diagnosis that once ended every argument in court now sits under sustained scientific challenge. Illnesses can echo the triad, like infection. Medications can also echo the triad. And in Nikki's case, even a fall from bed, just as her father said from the very beginning. 20 years of medical and legal reckoning have stripped away the illusion of certainty. The certainty that doctors once carried into the courtroom begins to look less like science and more like a set of unfounded assumptions. The biomechanical blow. The state argued that Robertson shook Nikki so violently that her brain tore, bled and swelled. But the records show there was no neck injury, no spinal injury, no grip injury or bruising, no rib fractures, no arm or torso trauma. Biomechanical experts testified that this pattern is physically impossible under the state's theory. If the shaking was violent enough to cause the triad, the neck would have been catastrophically injured. And it wasn't. Shaken baby syndrome did not fall because of a single revelation. It fell because its foundations were never as solid as the courts believed. And a man is scheduled to die on top of it. Chapter 4, The Law That Could Save Robert Robertson. Here's where the case turns, and this is where it gets worse, not better. In September 2013, Texas handed a man like Robertson a lifeline. It was Article 11.073, the state's junk science law. It had one purpose only, to pry open convictions sealed shut by bad science. When new scientific evidence undercuts the evidence in an old case, a judge can grant relief or even order a new trial. Andrew Rourke's case mirrored Robertson's on its facts. Same allegation, same triad, same expert witness, Dr. Janet Squires. The Court of Criminal Appeals acknowledged that a fall from something like an ordinary bed can deliver catastrophic injury, that shaking alone cannot produce the triad, that old bleeds can reignite, that retinal hemorrhages are not exclusive to abuse. The most persuasive evidence at the Rourke trial, the court said, had been overtaken by reality. Rourke's conviction was vacated. He walked out a free man. 1 week later, the state of Texas had a date to kill Robert Roberson. The same court that freed Rourke was 7 days away from executing the man convicted on the same doctor's words, the same theory, the same expert, the same statute, the same collapsing science. That is not a coincidence of timing. That's a system looking straight at its own mistakes and pulling the switch anyway. Now go back further, because Robertson's case has already been asked this exact question for years before Rourke ever got his answer. Robertson's legal team filed a habeas petition, a document that asks a court whether a conviction can stand when the science beneath it has fallen. They brought experts, new research, 2 decades of medical evolution. They showed that the triad was no longer presumptive evidence of abuse, not a fingerprint, not a signature, just symptoms with too many possible causes. The hearing itself took 2 years just to begin, and then the Anderson County Courthouse produced Nikki's original CT scans. Lost for 15 years, found in the basement of a courthouse. By the time the court finally ruled, 7 years had passed. 7 years for one word. The answer was no. 2 cases, 1 statute, opposite outcomes. Texas likes to say it leads the nation in forensic reform. It built an exit ramp for broken science, but the judiciary chose to keep driving towards the chamber. The lawmakers had been clear about why they passed the statute, and that was to fix the damage done by disproven science. And they were surprised that it wasn't a pathway for relief for people like Robertson. In the end, the junk science law showed both its powers and limits. It can open the door, but only if a judge turns the key. And for Robertson, the key stayed on the table. Chapter 5, The Remedy. A man is scheduled to die on top of a diagnosis that has already failed another man. That is not rhetoric, it's the current position of the state of Texas. But here's the flaw, exactly where the case breaks down. Shaken baby syndrome was never proven as a legitimate theory of abuse. It was the law's willingness to treat a hypothesis as fact, and then to freeze that assumption into law, making it almost impossible to unwind. In Robert Robertson's case, the diagnosis stopped being evidence and it became a verdict. For 2 decades, no courtroom was asked to notice the difference. Now, Robertson's case sits on a single question the state would rather not answer. If Rourke's conviction could not survive the science of shaking baby syndrome, how does Robertson's? The Court of Criminal Appeals has sent Robertson's case back to Anderson County, not for a pardon, not for mercy, for an evidential hearing, the first true examination of whether the evidence that convicted him can survive the science that replaced it. And even now, the state is buying time. 4 months granted, and then on the eve of the deadline, a request for 2 more months. No reason given, just more time, in a case where time is one thing that is running out. Delay is a litigation strategy. The question now is, when the science dies, is the state simply waiting for the prisoner to do the same? The remedy here is a hearing under a statute with a precedent on its side. That is the only thing standing between a father and the date on a calendar. For Robert Roberson, 3 symptoms became a verdict. 20 years, 2 stays, 1 signature, still standing between the man who spent 2 hours trying to revive his daughter and the death chamber. Next time we examine another case about shaken baby syndrome.